this time we're going to take up the matter of Northern Michigan Environmental Action Council and Priscilla Townsend versus the City of Traverse City and Pine Street Development 1 LLC. This is the time and place set by the court for issuing this bench opinion with regard to the issues that have been presented to the court. When this case last came before the court, it was to consider injunctive relief pending a referendum election to amend the city's zoning code. For reasons described at that hearing, the passage of time and legislative action had deprived the public of that right. The Traverse City Commission granted a special land use permit, SLUP, to Pine Street Development LLC on November 3rd of 2015. The court is now asked to review, on appeal, the SLUP and the application of Section 28 of the city's charter. The issues have been extensively briefed, and the court has reviewed the parties' briefs as well as the cases and statutes cited therein. The Zoning Enabling Act provides that a local unit of government may provide by zoning ordinance for the regulation of land, development, and the establishment of one or more districts, which regulate the use of land and structures to meet the needs of the state citizens. With respect to zoning decisions, the Michigan Constitution states that all final decisions, findings, rulings, and orders of any administrative officer or agency existing under the Constitution or by law, which are judicial or quasi-judicial and affect private rights or licenses, shall be subject to direct review by the courts as provided by law. This review shall include, as a minimum, the determination whether such final decisions, findings, rulings, and orders are authorized by law, and in cases in which a hearing is required, whether the same are supported by competent, material, and substantial evidence on the whole record. Substantial or substantive evidence is evidence that a reasonable person would accept as sufficient to support a conclusion. While this requires more than a scintilla of evidence, it may be substantially less than a preponderance. Substantial evidence includes facts based on inferences that are legitimate and supportable. The substantial evidence test is not whether a contrary decision could have been supported by substantial evidence, but whether the decision the agency actually made was supported by substantial evidence. A board's decision should be affirmed unless 1, it is contrary to law, 2, based on improper procedure, 3, not supported by competent, material, and substantial evidence on the record, or 4, an abuse of discretion. The special land use permit application filed by Pine Street Development 1 LLC contains at section 1364.02 a list of 8 general standards for approval. Among those, standards C and D state as follows. C, the use shall be served adequately by existing public facilities and services such as highways, streets, police and fire protection, drainage structures, refuge disposal, water and sewage facilities and schools, and D, the use shall not create excessive additional requirements at public cost for public facilities and services. The developers address each of these standards by stating that the proposed development will be adequately served by existing public infrastructure and does not necessitate excessive additional requirements at public expense. The special land use permit granted by the City Commission incorporates by reference a staff report dated October 29, 2015. This report states in conclusory terms that the proposed development will be adequately served by existing public infrastructure and services, but notes that street improvements will be made. The city goes on to reassure itself and the public that the project will not create excessive additional requirements for infrastructure, facilities, and services at public expense by referencing the same staff report and then stating, quote, the project will bring additional tax revenue, which will provide for additional infrastructure, facilities, and services, including through TIF and brownfield programs, close quote. The record is bereft of any document, staff report, or commission comment describing the source of the TIF funds, the amounts diverted from general tax revenues annually, and the time period the diversion will last. By law, a tax increment financing application and a brownfield application must contain a statement of the tax benefit sought and its impact on all affected taxing jurisdictions. Neither application has yet been made, and no draft applications may be found in the record, nor is there any other financial statement describing what the developer's total tax benefit is projected to be for the Pine Street project. At page 72 of the transcript, a commissioner spoke to the use of past TIF funds for public parking decks, streetscapes, bridges, sidewalks, and water mains. However, there's nothing in this record to demonstrate any public ownership of a parking area or a bridge after TIF funds are expended on the Pine Street project. To the contrary, the original Front Street streetscape project was paid for as a special assessment district. TIF 97, referred to by the same commissioner, did not even exist when the streetscape project was constructed. And the Riverwalk improvements mentioned in the staff report are not part of the Pine Street project and are envisioned as a future city expense. The same staff report indicated no need for water, electrical, or sewer improvements. So, apparently, undisclosed millions of dollars will be spent to bump up public sidewalks and install streetscape lighting and benches. If there is more public benefit to be garnered, it cannot be found in this record. Providing Pine Street with a private parking garage is certainly not a public benefit. No portion of this record may be remotely considered as a candid disclosure of the actual public expense, let alone an analysis of those costs relative to perceived public benefits. Almost unbelievably, the staff report adopted by the Commission discussing section 1364.02(d) refers explicitly to TIF as a source of revenue, as well as additional tax revenues generated by the development to offset increased municipal service costs, yet then finds the building will not create any excess expenditure with public funds. One cannot help but recall the Queen's comment to Alice on the practice of believing impossible things. Why, she said, sometimes I believe as many as 6 impossible things before breakfast. So it must be with city staff. TIF funds are local public tax dollars. They are neither state nor federal funds. TIF funds are property tax revenues being diverted from the numerous local general funds for the developer's benefit, and the developers do not pay for or contribute to city services for an undisclosed number of years. Evidence to the contrary cannot be found in this record. Without doubt, the Pine Street project contemplates street improvements and an impact on city services. The notion that 2 9-story buildings can be constructed with 162 residences and related parking and commercial space and not have any marginal impact on infrastructure, facilities, or services is absurd. The TIF and brownfield financing contemplated here are not the developer's contribution to city services such as highways, streets, police, and fire protection. To the contrary, those infrastructure costs, which are traditionally paid for by the developers, will instead be paid for with tax funds that would have otherwise gone to the city's general fund. In other words, the developers will be using these tax dollars to pay for hard costs associated with their own development, and will contribute no marginal revenue to support police, fire, or streets, which expenses are the largest components of the city's budget. It is hard to imagine how the City Commission determined this was a good idea without first considering the amount of tax forgiveness provided and the time period over which it extends. Not having crossed that basic financial threshold, the Commission was in no position to consider whether it was sensible for all other city taxpayers to support this development. Traverse City residents currently support police and fire budgets that dwarf those of its larger, more populous, and wealthier neighbor to the south, Garfield Township. The size of the police force reflects a substantial draw of tourists to downtown festivals, attractions, and to the city's restaurants and retail shops. Despite this already existing subsidy to the Central Business District development continues on the backs of residential neighborhoods and those non-TIF financed Central Business District properties. This form of taxpayer-funded development shows no signs of abatement. More stunning are comments found at page 71 of the transcript. First is the statement that TIF projects create growth that would not otherwise happen. There is nothing in the record to support this conclusion, and it is belied by the impressive commercial and residential growth in the surrounding townships without TIF funds. Then, without record support, a commissioner states that the baseline tax support would go from $13,000 to $60,000, quote, at a minimum, close quote. Such a staff estimate, if it exists, is not in the record. Finally, in the realm of believing impossible things, is the commissioner's comment that, quote, we are not, as a city, out of our general tax fund dollars, providing infrastructure to support this project, period, close quote. Streetscapes, lighting, bump outs, parking, riverbank stabilization, and environmental remediation are clearly infrastructure projects. One can and should debate the merits of using tax dollars for such projects and not pretend that TIF or brownfield funds are other than a diversion of public monies which would otherwise go to several general funds. In Section D of the staff report adopted by the city, the finding of no excessive additional services is accepted. In the preceding discussion found in Section C, the fire department's concern with maneuvering its 55-foot ladder truck is resolved. However, this truck may well be the single most expensive piece of city equipment. Should there be a fire and a 9-story building collapse on that truck, it is important to note that the Pine Street development would be contributing $0 to the truck's replacement. Those fire and police costs are now, and will for the indefinite future, continue to be entirely borne by the 1- and 2-story homes that make up Traverse City's neighborhoods. Within the record provided to the court, the developers appropriately abandoned the belief that this project could provide workforce housing. The developers have stated that they cannot discriminate in the allocation of public subsidized housing. As to the containment of urban sprawl, at least one commissioner recognized that the city's land use decisions can have no impact on urban sprawl. There is no action which the City Commission can take legally to direct the planning decisions of contiguous townships. Nor is there a serious argument being made that the construction of any building in downtown Traverse City will have any meaningful impact on the planning and housing decisions of those same townships. If other city commissioners are seriously justifying a massive tax subsidy on the backs of local homeowners to prevent sprawl in neighboring townships, it has not in any intelligent way discussed how it believes that would occur and why city residents should pay for it. An analysis and the evidence to support the sprawl proposition is completely absent in the record. The confusion some commissioners have over the city's property taxes is palpable. At page 89 of the transcript, a commissioner supports the SLUP and then states, quote, reducing the costs of the city by, 1, increasing the per capita share of taxes as we see more people living in a compact development, close quote. First, the city's property tax millage is assessed against real estate, not people. Second, increasing density does not change the property tax rate or the real estate to which it applies. Third, increasing density will not lower overall costs to the city within its existing limits. Adding people and building adds costs. That may well be a good thing, but it surely does not lower costs or taxes, especially where the new developments make no contribution to the general fund. Should the city believe it is so wealthy it can afford to give the Pine Street development and others millions of dollars in tax relief, there is no evidence that such a decision was made in the context of the city's own property tax millage, which is more than 4 times that of its contiguous townships. With a millage rate a fraction of that found in the city of Traverse City, Garfield Township has undergone massive economic development. Again, this development has occurred in the absence of tax increment financing. The city may believe that growth would not occur without TIF, but there is nothing in the record to support such a conclusion. One could argue that the city has less property to tax in its surrounding townships, and such an argument rings true. More than 40% of the city's land mass is not taxed. Therefore, the airport, the college, churches, schools, and parks, as well as governmental buildings, all support a regional population, but the city does not receive regional tax support. Commissioners should at least consider why the city should not maximize tax revenue from the property available to be taxed, as opposed to giving it away as construction costs to developers whose contribution to urban density will not carry with it for many years any form of concomitant tax relief for the services associated with it. The notion that brownfield or TIF funds are a county tax contribution to the city is also fallacious. Intercepting county taxes would benefit the city if they went to the city's general fund. They do not. Brownfield funds, properly administered, serve an important environmental goal. To the degree that brownfield funds intercept city and county general fund dollars to eradicate environmental contamination, those funds benefit the environment, but not the general fund of the city. To the extent brownfield funds do not address environmental contamination and are simply used to combat so-called blight, they are simply a disguised form of tax increment financing or another vehicle by which developers do not support the general fund, but use their tax revenues to pay for their own project. In this case, and to the developer's credit, at page 27 of the transcript, they have limited their use of brownfield dollars to remediation of contamination at the building site. Similarly, the interception of county tax dollars to pay for the developer's private parking garage, by definition, does not create publicly owned parking. There is no discussion in the record by any commissioner as to why the 162 residences subsumed within the Pine Street project should have the benefit of police, fire, and street services towards which they pay nothing for an undisclosed number of years. The same question could be asked of the 21,869 square feet of retail space and a 3,600 square foot restaurant. It is as though a substantial portion of Traverse Heights, the central neighborhood, or Slabtown, plus a block of Front Street, stopped contributing to the city's general fund. Someone must pay for these services. As things now stand, whether one lives on Peninsula Drive or in one of the Traverse City's more modest neighborhoods, the cost of those city services will be borne by local residents, including subsidies for the parking owned by the developers and used by their tenants and those who occupy the associated retail space. Should the City Commission actually review and intelligently discuss the billions of dollars of tax relief being provided for this project, and why such funding is actually necessary, and why local taxpayers should foot the bill for additional city services, then the objections become political, not legal. In summary, the developers provided an application for a special land use permit, which represents that they will pay for additional costs associated with the proposed development, but opines that such costs will not be meaningful. The developer's request for brownfield and tax increment financing has never been a secret. When the city issued a special land use permit, it specifically referred to an additional tax revenue stream provided by TIF and brownfield programs, and relied on a staff report that did the same. The factual finding that there will be additional tax revenue for infrastructure facilities and services other than in an undefined and distant future is categorically false. All of the additional tax revenue generated by this project will be used by the developers for their own infrastructure costs, including remediation of any pollution that may exist on the building site. Tax increment financing and brownfield funding are not gifts from the state or federal government. They represent local property tax funds, which would otherwise be paid by developers into the general funds of the city and the county. Certainly those in the city's neighborhoods who may wish to repaint or reside their homes or improve landscaping this summer are not equally allowed to deduct such costs from their property tax revenues to correct their perception of blight. In approving the special land use permit, the City Commission has either been hopelessly naive and uninformed with respect to the source and use of TIF and brownfield monies, or less than candid with the general public. The questions which the City Commission has never answered are, can it afford to deal with vacant lots by subsidizing the developments thereon for decades? And is it fair to do so by financing the marginal increase in the demand for services out of the pockets of every other city taxpayer? If the city continues to expend taxpayer funds in an effort to prevent taxpayers from voting on these projects, it would seem that some meaningful discussion regarding this type of significant taxpayer subsidy at city residents' expense should occur. The city should take a look at the cost associated with its entire participation in the brownfield and TIF programs, the properties eligible for consideration, and be prepared to explain why city taxpayers should pay for a substantial increase in urban density and the services associated with it. And in so doing, the City Commission should candidly recognize that it cannot limit publicly subsidized housing to downtown workers, and it cannot legally impact land use decisions of contiguous townships who have their own independent authority to plan and zone. Remanding this permit to the City Commission for further consideration will not be quickly or easily accomplished. A meaningful public hearing that allows comment from both sides regarding the financial costs and perceived benefits and who is actually paying for them will be controversial. A substantive discussion of comparative property tax rates, the realistic limitations on the control of sprawl, and the impact on the city's general fund all require serious discussion and not simply the incorporation by reference of conclusory and occasionally unbelievable statements made by members of city staff. It is also important to emphasize that these concerns are vital to the community and exist irrespective of any building's height. As the court noted during the recent oral arguments, if Section 28 applies to this project, it applies irrespective of the building's height. And if Section 28 applies to every project that has utilized TIF funds, the public is undoubtedly stopped from asserting those rights as to past projects. The argument that other projects were not subject to a public vote and perhaps approved by the city in decisions equally bereft of meaningful financial analysis is no excuse not to engage in a thorough consideration of the financial costs and benefits associated with such projects in the future. For all the foregoing reasons, the court remands this matter to the Traverse City Commission for a cogent analysis of the project's impact on infrastructure, facilities, and services, the source of funds to pay for that impact, and an intelligent discussion of the perceived benefits that support justifying such extensive public subsidies on the backs of local taxpayers. If the Commission has this discussion and believes it can justify its decision, it will explain why and approve this SLUP once more, and with a more robust record. Only at that time would the issue of Section 28 become ripe for consideration. Furthermore, in fairness to the parties, the court believes some comment should be made with regard to Section 28. The first is that Brownfield, TIF, and MSHDA housing dollars are all public funds. If there is no other impediment to the application of Section 28, then the use of those public funds would arguably trigger the need for an election. However, the court believes that the Brownfield subsidy for environmental remediation and removal of contamination not caused by the current property owner reflects an overriding state policy which would prohibit a Section 28 public vote. The court is not so convinced that merely calling a property blighted and disguising what are otherwise economic development funds as brownfield dollars should be similarly treated. The MSHDA housing subsidies are derived from Michigan's implementation of a national housing program to provide subsidized housing to low-income residents. To the extent that this national policy exists and is implemented by the state of Michigan, the court does not believe that Section 28 could be used to require a public vote on MSHDA financing. Tax increment financing is a creature of state law, but it comes with no state or federal subsidy to the city or the county. It is simply the use of the developer's local property tax dollars to support the developer's own project in derogation of a contribution to local jurisdictions' general funds. If Section 28 applies, it does so to control the seeming unrelenting willingness of city commissioners to spend the dollars of the many to benefit the few. This opinion resolves the last material issue presented to the court. The special land use permit is now vacated, and the case is hereby remanded to the City Commission for further proceedings consistent with this decision and order. Thank you very much.